Hi, I'm Sylvia, an arbitrator, mediator, and attorney located in Houston, Texas, serving as neutral in cases all around the country. Thank you for clicking on Mayor on Mediation and Arbitration. Today, I want to talk about arbitration and preliminary case management hearing and scheduling conferences. Every arbitration is unique. The parties, the facts, the law, the complexities, the procedures, the schedules, the deadlines, the issues, everything is different in each case. But there are certain things that you can do on all of your cases that will help you. So here's a few real-world brass tacks practice tips that do not change from case to case. So keep these in mind as you prepare for your next preliminary scheduling conference. To quote Jerry Maguire, I offer these tips so you can help me help you.
Help me help you.
Preparation. Let's start there. Preparation. I prepare for every preliminary hearing conference. I read the pleadings. I look over the rules. I consider any information I have in the file. You should prepare too. You should read the pleadings. You should look over the rules. You should consider any guidance you may have received from the arbitrator or arbitrators. In many of the administered arbitrations, the administrative body has rules that spell out for you what is going to be covered at the preliminary hearing conference. And you should read through that and think about the issues that are listed. For example, the American Arbitration Association's commercial arbitration, their rules, Rule P-2, provides a list of everything covered at the conference. For the International Institute for Conflict Prevention and Resolution, also called CPR, they have rules for administered arbitrations, and their Rule 9.3 contains a list of the topics to be discussed. If you'd like to find a link for each of these rules, you can find them on my website in an article that I've written that talks about this very topic. All right, so we talked about preparation. 2, time. You are busy. I understand that. I'm busy too. You should understand that as well. If there's information that you want me to review before the conference, then please provide it far enough in advance that I have the opportunity to review it. Also, time. Emergencies happen, and I understand that. Deadlines, they happen too. Keep an eye on the schedule and the deadlines established for the arbitration. If you do not already have a tickler system, then you may want to get one. A tickler system is where you set reminders for yourself about upcoming deadlines so that you don't miss any. Now, time number 3. We are all busy professionals, but you know what? We are also people too. So when setting deadlines and schedules in an arbitration, I consider the parties' input and the need for a fair, efficient, and economical resolution of the arbitration. But I also take into consideration holidays, vacations, and personal commitments, because we're people. So please do not propose a schedule that is intended to jam the other side. All right, we've talked about preparation and time. The third thing I want to talk about is dialogue. Meet and confer. Meet and confer. This is really important. As I've already mentioned, the topics to be discussed at the preliminary hearing conference are often listed in the administrative rules for the group administering the arbitration, or perhaps in a pre-hearing communication from the arbitrator. Discuss these issues with opposing counsel in advance of the conference. It will help to streamline the hearing. It also helps to establish a foundation for future dialogue. Most arbitrators, this one included, will encourage or order the parties to meet and confer about disputes throughout the arbitration before seeking arbitrator intervention. So if you meet and confer before the first conference, you've already begun that process that you'll be repeating throughout the arbitration. In conclusion, prepare for the preliminary hearing conference by using your time wisely. Review the papers, review the rules, review guidance from the arbitrator. Confer with opposing counsel to explore the topics to be addressed during the conference and to identify areas of agreement to narrow the procedural issues and any disputes. In summary, to quote Jerry Maguire again, please help me help you. Thank you for joining me today. Please connect with me on LinkedIn or subscribe to my YouTube channel. If you have any questions, please comment below.